From 12th of August 2016, we'll have to consider how the Insurance Act affects insurance policy claims. This video follows on from my previous one that gave an overview of insured's new duty to present the risk fairly. If you haven't watched that video, then I recommend that you do so now, otherwise you're going to get a bit lost. This video covers how to assess what material circumstances an insured should disclose. Before we get into that, you should also by now have downloaded a copy of our distinctive booklet on the Act, so that you can refer to it while you watch the video. You'll find a link to the booklet on the page where you found this tutorial. So let's get started. In the last video we looked at the overview in relation to non-disclosure and misrepresentation that you'll find on page 3 of the booklet. We considered the insured's new duty and asked whether there had been a fair presentation of the risk. That required you to turn to page 5. We went through page 5 but left one particular box that I said would require further consideration. I'm going to do that now. This is a question of whether the insured disclosed every material circumstance that it knew or ought to have known. For that you will need to turn to page 7 and follow the flowchart there. In some ways this is the most important part of the process of assessing whether an insured has discharged their obligations or not. This chart will explain to you how to assess whether the insured provided all the material circumstances required of them. We'll work through this chart until you obtain the answer whether the insured has disclosed every material circumstance that they knew or ought to have known about. The first question is connected to the definition of material circumstance. That is really information that a prudent insurer would want to know about. If you're considering this as part of a claim, you probably already have some information of this type. What you should have is evidence of a circumstance or representation that would have influenced a prudent insurer's decision as to whether to take on the risk or whether to take it on under different terms. If there is such evidence, then you need to move down through the chart. If the answer is no, then insured has already disclosed every material circumstance that it knew or ought to have known. The grey box here reminds that this is a material circumstance, which is a term used by the Act. When you move through the next question, you see that they are asked whether the insured was an individual or not. Depending on whether they are or whether they are a corporate entity will depend upon how you conduct your investigation. The next grey boxes will tell you who you should be talking to and whose evidence is important. Follow the yes to the left and you have to investigate whether the material circumstance was known to the individual who is your insured or the individual responsible for the insured's insurance. If you follow the no to the right, then your investigation is with senior management of the corporate entity or the individuals responsible for that insured's insurance. You carry out those investigations with the next few questions in mind. You'll have to find out from either the individual or senior management whether the material circumstance was known about. If it was known to them, then they are in breach. If it wasn't, that does not automatically mean that they have discharged their obligations. If you answered yes, then you'll see that you're taken to the green oval that indicates that the insured did not disclose every material circumstance that they knew or ought to have known. You'll take that information back to page 5 and plug it into the relevant box. If that information wasn't known to the individual or the insured senior management, then it's not the end of your assessment. You then have to ask whether the material circumstance would have been reasonably revealed by a reasonable search of information available to the insured. The word reasonable is a very lawyerly word that provides a lot of wiggle room. Some judgment is going to be required as to whether the insured or senior management could have discovered this information if it searched within their organisation, however big that organisation might be. A reasonable search for a small company would be quite different to one for a large multinational. It will all depend on the particular insured and the business they operate. If that information would have been revealed, then you follow the yes answer, and again you're provided with the conclusion in the green oval that the insured has not disclosed every material circumstance. But if that information would not have been revealed by a reasonable search, next you will see there's another question within a blue box that requires further consideration. You find that on page 9. I'm not going to go through that now. What you're considering is whether there was information known to a broker or someone within the insured's organisation that was responsible for placing the insured's insurance. Page 9 deals with certain exceptions to what a broker is deemed to know about. That principally covers a situation when they learn confidential information through another one of their clients. They're not required to disclose that, it would cause them to breach that duty of confidence. If the answer to the question in the blue box is no, then you move down to the conclusion that insured did disclose every material circumstance that they knew or ought to have known. You now take your answer, be it yes or no, and turn back to page 5. And here you will insert the answer into the blue box and work your way through the flowchart. I explained how to do that in the previous video. That in turn will help you to understand whether the insured has made a fair presentation of the risk, which will lead you through the rest of the flowchart on page 3 to discover whether the insurer has a remedy or not. This has been a close look at a specific part of the Act and how to consider whether an insured has taken the appropriate steps to disclose all material circumstances that they knew or ought to have known. You can watch other videos in this series to learn more about the Insurance Act. I'm Michael Hogg, a partner in Kennedy's London office. The Insurance Act 2015, a distinctive approach.